welcome to Legal Links, a legal information program brought to you by the Oregon State Bar. My name is Steve Todd. I'm a pro tem circuit court judge serving Multnomah County, and I'm a proud member of the Oregon State Bar. Today we'll be discussing caring for aging parents. This is a two-part program with this episode covering how to plan ahead, and the other episode will be on what to do when a crisis hits. If you miss a program, you can view them later online from the Oregon State Bar website, which is www.oregonstatebar.org. With us for today's discussion are Lisa Bertalin and Jeff Bernhardt. Lisa's been practicing law for over 19 years, including 15 years as a municipal judge of the City of Bend. She specializes in estate and tax planning, probate, and elder law. She serves on the editorial board of the Oregon State Bar Estate Planning newsletter, and she's drafted several bills that are now law to protect Oregon seniors from financial and physical abuse. Jeff is an elder law attorney in Portland, and he's been helping older people and their families address the legal and financial consequences of aging for over 17 years of practice. He's been a frequent guest speaker on estate planning and elder law, as well as a contributor to the bar's publications. Welcome to you both. I'm so glad we can have this discussion today. I know a lot of people in the audience, including me, need to know more about how to deal with aging parents. And I guess the first question everybody wants to know is, what kind of documents do we need? Lawyers deal with documents, but the average person just doesn't know. Do we need wills? Do we need trusts? What are all the papers people should have in place?
Well, Steve, when we're advising older people and their families, we are generally looking at two different situations. We want to have planning documents in place to deal with the possibility, number one, that somebody might pass away, and that the other possibility is somebody might not pass away, but rather become disabled and not be able to handle their own affairs, and someone needs to be able to step in to do those things for them. So in terms of the basic, what I would call ducks in a row planning, the first document that a person needs is a will. And a will is simply a document that specifies where a person's assets will go after they've passed away, and nominates an executor of their estate to basically gather their assets, pay their bills, do their final tax returns, and then to distribute the assets to the beneficiaries. Another document that some people might consider that's like a will is a living trust, and a living trust is generally for estates that are a little larger, maybe something over $250,000 or so, and the main advantage to a living trust is that it avoids probate, which is where the court supervises the distribution of a person's estate. So those are the planning documents that we consider to deal with the possibility of somebody passing away. What fewer people think about is the possibility that you might not pass away, but rather that you might have some type of serious illness or injury, something like a stroke, or come down with dementia or Alzheimer's disease, where maybe you're going to live for many years, but you don't have the ability to make things like important healthcare decisions and financial decisions. And so the two primary documents that we're looking at there is a power of attorney for finances, which is a document that a person can sign that says that if they're unable to make their own financial decisions, that they're going to appoint someone to do it for them. The second document is called an advance directive for health care, and that's a document that specifies that if a person's unable to make their own health care decisions, well, it does two things. It authorizes someone to communicate your wishes about your health care, to review your medical records and talk to doctors, and it also provides that person, which is called your healthcare representative, with information about what your wishes would be if you were ever in a situation where you could not direct your health care. The last thing to consider is what I would call a long-term care plan. The average cost of long-term care or nursing home care in Oregon is about $6,500 a month right now. And let's face it, not all that many people can afford that. So people should be considering some type of a plan for how would this care, how would we get quality care for a person who's ill, while perhaps also making sure that someone like a healthy spouse or a disabled child would also be taken care of. So I would describe those as sort of the basic documents that every older person should be looking at completing.
Lisa, we all learned in law school that if you don't have a will, the state of Oregon basically decides through the law what should happen to your assets. And the same thing's true for healthcare and other things, that there are certain laws in place. If you don't have anything written down, the government decides for you. Is that a fair way to say it?
Well, not necessarily. It usually can go to a court where if you don't have these documents in place and you haven't done what I call sort of above the line planning for incapacity during your lifetime, then interested parties, whether that be a family member, an interested neighbor, a caseworker, can petition the court to have somebody appointed for you to make those decisions. That can either be a conservator who makes decisions about your finances, pays your bills, manages your financial affairs, or a guardian, a person who's appointed by the court to make health care decisions for you. Now, who gets appointed is under the jurisdiction of state law and the judge who makes that appointment. But if there is objections or if people aren't in agreement as to who can serve, then there is a hearing process and due process provided, of course, to the older person and family members so that they can let their wishes be known, and then the judge can make an appropriate decision about who is going to assume those agency roles on behalf of the older person.
But of course, what we're talking about today is if you plan ahead, that you won't need to go through that expensive probate process.
Well, that's always the hope, and I get that question a lot from my clients. So now I've signed these documents. I've signed my power of attorney appointing my oldest son as agent. I've appointed my daughter as healthcare representative. How do I make sure that my wishes are carried out then when I do lose capacity and these people are making decisions for me? Or I may have Johnny come in and say, my father can't take care of his finances, or he needs to go in a care facility. It's dangerous for him to be at home, but he won't leave the home. And now what options are there for me? So those documents in place give somebody the legal authority to make those financial decisions and make those health care decisions. But what a lot of people don't realize is there's an emotional component, of course, always to making sure that those wishes and those sequence of events are carried out. And what I usually counsel people is to seek a support system and seek, if you do need at that point, then further guidance from a court, that you should seek that.
Oh, sure. Well, let's say you have these documents in place. Where do you keep them so everybody knows when you're incapacitated where to look for them?
Well, that can be a number of places, and some people have safe deposit boxes at banks. But the big question when clients come into me and say, well, I'm going to put them in my safe deposit box, and I say, well, who else is on the box with you? And they kind of look at me, nobody. So make sure that at least there's somebody that you trust that's on the box that can get into the box. So if your original will is in your safe deposit box and nobody else can get into it after you die, that could be a problem. A lot of my other clients will have safe boxes at their home or lock boxes, but I always encourage them to make sure that these are fire rated. I have had situations where people have lost important original documents in a fire at their home, and so you want to make sure that you've thought about that ahead of time. Back in the olden days, attorneys would keep original documents in their will safes in their offices, but I don't think the bar is recommending this any longer. But I think, too, that it's up to us as attorneys to counsel and ask our clients, when you hand them their original documents, where are you going to keep these, and making sure that the people that need to have a copy.
Now, copies, that's another question. Should you mark which one's the original, which one's the copy, and where should you put the copies? Jeff?
Well, you definitely want to be able to distinguish the original from the copies. The original Lisa mentioned, usually a safe deposit box, some type of a fireproof safe, or a file cabinet that's fireproof. In terms of the copies, it's a very interesting question, because for the things like wills and powers of attorney, these are documents that primarily deal with financial decisions. I normally advise clients to keep those kind of close to the vest, because those are their personal estate planning decisions, and that these are documents that can be revealed, when the need arises. But I have a little bit of a different attitude about the healthcare documents, and my belief with those is that they really should be kind of spread far and wide, and so that at a minimum you want to maintain possession of the original. You want to make sure that your healthcare representative knows exactly where to find that original. I also advise people to have a copy of the healthcare directive put into their medical chart, and then also to be provided to anyone who's named as a healthcare representative representative. The other thing I do also is I put them on flash drives for people so that if they're traveling, for example, they go to the coast. I just heard enough complaints from clients who had gone to the beach and they just didn't have that 4 to 8 page document with them. And also hearing from emergency room doctors who said, hey, that document's great, but if I don't see it, I don't know what to do with it. We started creating electronic copies of them.
Wow, that's a great idea. Well, you just mentioned something else. People would probably want to keep a list of medications and doctors, and that's because when they're incapacitated, nobody else will know how to get their medicine.
And so communication is always key to making sure that your estate plan and your wishes are carried out. And I encourage my clients to, once they leave my office, give them a checklist and sort of a workbook, so to speak, of where those important documents are, what their accounts are, who their professionals are that they rely on, their attorney, their doctor, their accountant, their insurance agent, to list all that information so that the person that is going to assume that role as agent or healthcare representative doesn't go into it blindly. And I really think that people don't do that, and then they assume that their children will know what to do, and it's very hard to piece together somebody's life who is incapacitated from gathering the bills and the mail and digging through pharmacy records and medical records, so to speak.
Maybe just some contacts, just the names of the neighbors and how to reach their friends
Absolutely.
if there's an emergency. Well, how do you open up this kind of discussion? Because people don't really want to think about what might happen if. How do you get that discussion started?
I have some ideas about this. Many people, especially the generation of people who are, in their 80s right now, these are the people who went through the Great Depression and World War II and have tended to always keep this information close to the vest and it's private. And of course, some aging parents who have adult children, there are certain conflicts that develop in terms of the aging parent worried about the children kind of crossing boundaries with the parent about their financial affairs and the parents wanting to maintain their independence. Mm-hmm. And so one does have to approach this topic in a delicate fashion. And my favorite way in terms of advising the adult children is to talk about someone else. Someone that they've seen, like, my friend Jim, his father just had a stroke, and they're going through all these kinds of issues, and it turns out they didn't have power of attorney, they didn't have a health care directive, and things are really a mess for them. And I'm just wondering if this is something that Mom and Dad, you guys have looked into.
Well, I would think certainly when you think about it, it's the most stressful thing on the other person is not only worrying about you being in the hospital, but then they have to reconstruct all this information.
Right. And I also have gone at it from the opposite approach, Jeff, where I've encouraged the children to get their own estate plan in order and then go to parents and say, look, we did this and it was easy and it was inexpensive, because expense for this generation that you talk about, the Depression era generation, expense is a concern, and the idea of going to an attorney can be daunting. And so sometimes if you get the children to engage in that process first and then go to parents and say, look, Mom and Dad, we did this, it was simple, we did this so that our kids won't have to reconstruct and there'll be something in place for them. Sometimes that gets the parents to do that as well.
That's a great idea. Well, sometimes I tell people the only thing more expensive than an attorney is not having an attorney. So maybe that's not fair, but really it doesn't seem like it costs that much for just some simple advice and getting somebody started. Where should people start if they want to get some legal help?
Well, you can always contact the Oregon State Bar referral system. You should also talk to friends and neighbors. Who have they gone to? Who have they used? Because I think word-of-mouth referral is often the best. If you know that your neighbor went to somebody and they had a good result, chances are that attorney is going to provide you the same level of service. Mm-hmm. What I counsel people to avoid is those I call them estate planning mills, where you go and you may be traveling, somebody may be traveling through town and selling an estate planning package, because oftentimes those aren't tailored to that individual's specific needs. And it's good to have a relationship with your attorney that's long-term as your life progresses and things change.
That's such a great point, Lisa. The relationship is the way I look at it as an elder law attorney, is that my job job is to provide a roadmap for this period of time that people are going through the aging process, to show, where are the dangers, where are the opportunities, and then not only to say, well, here's a map, good luck, but rather to, walk the path with the client and to be there when they're needed. And so you really do want somebody that you think is going to be there for you, 3, 5, 7 years later.
I've always thought it's interesting with doctors, we get annual checkups. We don't do that with the lawyers. It really might be wise to have a lawyer check your will every few years, or if things change.
I think good lawyers and lawyers that do want to develop that relationship with their clients do send out checkup letters, contact their clients. With the advent of email, and frankly, a lot of my older clients are on email. They email me all the time, which is wonderful. And just an update, how are things going? Are there any changes that you need? Do you need to come in for an appointment? And then also after they sign their documents, putting them on some sort of an update checklist. Every 2 years having a letter go out of your office. Is there anything that needs to be updated? Anything you'd like to talk about?
That's really true. I see people in court that bring in forms that are old, very, very old, and they've never updated anything. So that's important. Well, let's talk a little about care options, because that's the biggest financial concern for most people, I think, is how to care for parents health-wise. What are some of the programs that are available? We were talking earlier about Medicare, Medicaid, Social Security.
Sure.
What's the difference?
Well, Jeff, if you want to address the differences, and I can comment about levels of care.
Okay. You mean in terms of the programs that you just mentioned? I think most older people are pretty comfortable with Social Security and understanding that it's essentially a pension. When people reach a certain age, they qualify if they've earned enough work credits. The big question that older people tend to have is the difference between Medicare and Medicaid. Very confusing. They're very similar terms. And so when people, for the most part, when they reach age 65, they qualify for benefits through Medicare. And what that is, it's sort of a form of health insurance that tends to cover doctor services and hospital care very well. The downside to Medicare is that it doesn't cover long-term care very well. There's just a very small benefit for people who've been in the hospital for at least 3 days can qualify. Medicare will pay for days 1 through 20 in a skilled nursing facility. And then days 21 through 100 have a copayment that's in the $133 range or so. But when the person no longer needs skilled care, the Medicare benefit runs out. And this is a real shock to people, because all of a sudden the bill is going directly, for the long-term care, is going directly to the older person. And so this is where people maybe will hear the term Medicaid for the first time. Medicaid is another government program. It's administered by the state of Oregon and funded by the state and the federal governments. And the main difference is that Medicaid will help with long-term care costs. Another primary difference is that with Medicare is not a means-tested program. And so what that means is you can have millions of dollars in the bank and you'll still qualify for Medicare benefits. But if you need assistance with long-term care through Medicaid, there's a process where the state will evaluate your assets and income to see whether you're eligible. And this is also a big surprise to people. So that's the primary difference. Medicare covers doctors and hospitals very well, does not cover long-term care very well. Medicaid can cover long-term care, but only if your assets are reduced to certain levels.
So Lisa, let's hear your comments about that.
Well, there's other ways, too, that Jeff didn't mention to pay for long-term care. Of course, you can private pay if you can afford it, and long-term care insurance, which I do encourage my clients who can qualify, are young enough to afford reasonable premiums, to look into purchasing long-term care insurance that will cover not only nursing home care, adult foster care, assisted living, and in-home care services. I find that most of my clients want to stay at home, and usually this is their primary goal. And so most often they come in asking, how do we set things up so that I can stay at home as long as possible? And that can be through family support, that can be through private paid in-home care services in your community. And that could be also assisting help from friends and neighbors to make sure that that person stays as long as possible, as long as it's safe. A lot of times I see clients, though, get into a situation where an elderly spouse is providing all of that in-home care, and that can be dangerous because it may put the healthy spouse in a situation where now her own health is in jeopardy because she's exhausted emotionally, physically, and may not be in a position to take care of the ill spouse at home.
Can you pay a relative? Let's say you had a nephew that was able to do that. Could you pay them to do the in-home care?
Well, the simple answer to that question is yes. But if you're thinking in terms of future qualification for Medicaid, what Jeff explained is a means-based program where they look at your assets to see if you qualify. They also look at whether you gave assets away in order to qualify. So checks written to family members are suspect. And so when I have clients who are seeking to hire a son, a daughter, a niece, a nephew as an in-home care provider, I make sure that it's pursuant to a written care agreement and then making sure that we don't run afoul of any gifting rules under Medicaid.
You just touched on something a lot of people want to know about, because before it gets taken away, can you give away the house to the kids so that the government doesn't take it?
Well, it's a very complicated issue. Again, this is a means-tested program, and so when people hear that, okay, you have to, before you'll qualify for Medicaid, you have to spend down to certain levels, one of the first thoughts that they have is, okay, well, I'll give these assets to my kids, and then tomorrow we'll go down and apply for Medicaid. And, well, that doesn't work all that well. One of the questions that you get on the Medicaid application is, have you transferred any assets in the last 5 years? And so you have to disclose this. And if you have transferred assets, what happens is that in most cases there is some type of a waiting period or a penalty period that's imposed. So the determination on your application will be, well, you would qualify, but you gave your house away to the kids a couple of years ago, so come back in 3 years or come back in 2 years, maybe come back in 5 years, and you'll qualify for these benefits. And so this can be something where typically the person who's making the application is out of money and they're needing the benefits right then and there. So it's not totally impossible to do this, and there are some exceptions within the rules, but one must be extremely careful not only of running afoul of these Medicaid rules, also looking at there's some significant tax consequences that go along with transfers of assets, especially real estate. So this is something you want to be very careful, and you want to make sure that you've got good advice from an experienced elder law attorney before transferring any assets.
Because I can imagine the capital gains issues must be very tricky.
Sure, because when you gift an asset away, you inherit the basis of the person that gave the gift to you. So whatever mom or dad paid for the house now becomes your tax basis. So when you go to sell that property, you pay the difference in terms of capital gains tax between the tax basis that mom and dad had and the new sales price. And if that's $100,000, you're going to have a significant tax burden when you sell the house.
So instead of doing your kids a favor, you could be giving them a big tax liability.
And the flip side, too, in this down real estate market, and especially I'm from Central Oregon, is the kids may say, well, if mom or dad run out of money before the 5-year look back, before the penalty period runs, we'll just sell the house and then use that money to pay for their care. Well, if you can't sell that house, that's not going to work. And a lot of people are in that position in this down real estate market where now mom or dad's run out of money, the house can't be sold, and mom or dad don't qualify for Medicaid because of the gifting rules. So be very, very careful when you start giving your assets away.
Another big issue that people worry about is funeral expenses. Are there ways to pre-plan for that?
Sure. And what I like to tell the clients is that generally it's a pretty good idea. And the example that I give them is that funerals and weddings have something in common. There are these big family events, and there's lots of work to do to plan for them. But for the wedding, you might have a year to get everything together, and for the funeral, you might just have a couple of days. And I remember I was raised by my grandmother, and when she passed away, she hadn't told me anything about her funeral planning. And so I went out and immediately bought, everything she needed for her funeral, only to find later on that she had done all of that work herself. And so so it's kind of like a nice gift because it allows the relatives to be grieving your loss instead of working through a whole bunch of logistical issues.
Now, your plans wouldn't necessarily be in the will, would they? It'd be
No, and that goes back to what you were asking before about how do I, what information should I disclose ahead of time to my children so I can make this process easier for them. And so having your funeral plan put in a place where your children will find that. If my clients tell me they have a funeral plan, I make a copy of it and I put it in my file, because most often when the client dies, the children will be calling me asking these questions and whether I have this information. So it's a good idea when you're listing those important people and the account numbers to also include that as well.
And being a veteran, it makes a difference, doesn't it?
With regard to funeral planning or long-term care?
Too.
Well, there are certain veterans benefits that people may be qualified for, and Lisa mentioned them earlier, or mentioned veterans benefits earlier. The one that is sort of the least well known is something called aid and attendance benefits. And what it is it's a benefit for military veterans who served our country during wartime and who are now over age 65 and who need some assistance with what we call activities of daily living, help around the house, assistance with bathing, dressing, grooming, and the like. And what happens is the veteran can go and apply through the Veterans Administration, and if they're approved, right now the VA can pay up to a little over $1,600 a month towards the care of the veteran. The other thing is that a veteran's spouse can also be a beneficiary of this. So if it's the spouse who's needing care, that spouse can receive something in the range of approximately $1,000 per month. This is something of a means-tested program as well. The general rule of thumb is that you would qualify if your assets are under about $80,000 plus your house. And then you would need to have some relatively significant care expenses. And so, for example, if you had pension and Social Security income of $3,000 a month and your care costs were only $1,500 a month somehow, you're not likely to qualify. On the other hand, if you've got $3,000 a month coming in and your care costs are $5,000 a month, then that's a situation where you likely would qualify.
Say you have a relative you know is likely to need nursing home care. What can you do now before they actually need it? Are there planning things you can do?
Well, certainly getting the documents that Jeff mentioned earlier in place is imperative for everybody, but certainly that population that may need nursing home care in the future. In addition, start looking at long-term care insurance. Maybe they're at a situation where they would still be able to purchase a policy, and researching local facilities in your area, nursing home, assisted living, adult foster care, asking those important questions. And as Jeff so eloquently put it at the beginning, getting your ducks in a row, really.
Well, that's exactly what we were talking about this show. We're going to have another show on what to do when things get wrong. That's all we have time for today. So thank you, Jeff and Lisa. We'll be coming back with another show. We really appreciate your time on this show today. More information about this subject and other subjects is available to everyone online, just visiting the Oregon State Bar website at www.oregonstatebar.org. There's a wide variety of information on that website. I hope you check it out. Well, that's all we have time for today. I hope you can join us again and found this program helpful and see our second program. And I'll be seeing you again soon on Legal Links.